My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me about. The patient is entitled to recover money from the party who injured them, and it demands that the insurance company pay money in settlement of the claim. Now, in my office anyway, we sit down with the patient, our client, and talk to them about what the value of the claim may be, and we agree on a figure that we're going to ask the insurance company to pay. Two things that a person needs to know about that figure. One is the insurance company will never pay it. They'll expect to negotiate. And two, everything that has to be paid comes out of that figure. So, for instance, there's an attorney fee that gets paid out of the figure and costs. And if the patient's own insurance company or carrier has paid for treatment already or for wage loss, they're entitled to be repaid frequently with, they're required to make a contribution to the patient's attorney's fees and costs. That's the law of the state of Washington. In Oregon, the other state I practice in, that works a little bit differently, but it's a little too complicated to go into in this one video. But so whenever you talk to your attorney and you're talking about money, you're talking about a gross sum of money, and you need to ask the attorney what gets paid out of that, because what you as the client are going to be interested in is what you will recover in your pocket. So we send that settlement demand out, or that legal evaluation, which is what it is, asking that the insurance company pay a sum of money in settlement of the claim, and that opens a period of negotiations, which is usually 1 to 2 months, can be longer, can be a lot shorter. And the insurance company can be expected to counteroffer with a much lower sum in response. Sometimes it's shockingly lower, and then we go into a period of negotiations to figure out whether we're willing to settle for the maximum amount of money that ultimately we can get the insurance company to agree to settle to. Now, my practice is I never submit a sum of money in settlement of the claim unless my patient or my client has agreed to that in advance, or unless they authorize me to accept an offer made by the insurance company in settlement of the claim. And we work to try and maximize the amount of money that the insurance company will voluntarily pay. And normally we get them to an amount where they'll say that's the most they're ever voluntarily willing to pay. When that happens, the client has a choice. One, they can have us settle for that amount, or two, they can have us file a lawsuit with the idea of going to a trial by jury to recover money against the party that hurt them, which their insurance company would be required to pay. And generally, that's how claims are processed. Most cases don't result in the filing of a lawsuit. Those cases are settled through negotiation. Other cases result in the filing of a lawsuit, and most of them never go to trial and result in a negotiated settlement, even though we've had to file suit. But that's the way in which claims are processed. If you have any questions, you can call me if you're interested in having me look at your case, and I'll be glad to talk to you. Nice talking to you this afternoon.